Good evening. This side Rahul Bagan here as a Group Chief Executive Officer, Treasury Consulting, and also a venture capitalist. As we speak, Treasury Consulting Group is a multinational headquartered group based out India, Singapore, and Hong Kong. More importantly, we do have offices in three parts of the globe, and apart from that, we operate our own hedge fund, which is proprietary in nature. Now, by proprietary, it means that we invest our own capital. We do not invest third party capital, which means that you may be a millionaire or billionaire, but if you give your capital to us, we will not accept your capital. We only trade our own capital. Apart from that, we have our many learning platforms, Sheetal Academy, TRFX Academy, our own paid news desk, and many more product training programs and all. There are many more products. In case you wish to have any information, you can definitely WhatsApp on my personal number, which is +91 9899242978. Alternatively, you can WhatsApp on our back office, which is +91 9818485155. As you know, that Treasury Consulting believes in knowledge. Since inception of my career in 2007, in fact before when I was doing my studies, I never believed in theory. Rather, I'm a very strong believer of the fact that majority of the interpretations which are done not in India, worldwide, they are done in the absence of knowledge. So let's take an example today. Reserve Bank of India said, Reserve Bank of India governor said, India needs a very strong audit system. I remember there is a story of Shiv Puran. Shiv Puran means basically based on Mahadev, Lord Shiva, in which Lord Shiva was guiding to his elder son Kartikeji, and he was telling to Kartikeji that just saying food doesn't mean the food will automatically cook and it will come before you and you just eat it. No, it's not like that. You need to work for this. You need to cook the food, which of course needs time, effort, energy. Sometimes you fail, sometimes you cook a much better food than you earlier cooked. At the end of every session, you ends up a more experienced person than you was. Alternatively, what Lord Shiva was trying to convey to Kartikeji was that with every thing you do, you ends up having a better experience than the earlier one. And what he was talking to Kartikeji was, just saying food doesn't mean food will come. You need to work for that. Similarly, just saying that India needs a holistic audit system doesn't mean India get holistic audit system. To get holistic audit system, you need to work for this. And this requires years of effort. But the problem with the Indian regulator is they only give statements. Zomato, Barbecue Nation, your Devnani International, Paytm, Pesa Bazaar, MobiQuick, all are launched or approved. You expect India to be a holistic system with a complete audit functionality. So, what is that? Interpretation. Interpretation is the most important thing. People don't interpret things. Now, our law desk is on. We are interpreting things from a different angle. And law is all about interpretation. How you see it, that's more important thing, because even in the Supreme Court, not only in India, but anywhere in the world, Supreme Court of India, Supreme Court of Singapore, Supreme Court of United States, one thing that matters how you interpret the thing, how you take the things forward. So today I would like to interpret Section 7 of the Indian Arbitration Act. And here I would like to request Supreme Court of India, Honorable Supreme Court of India, to please consider what I would like to convey. But before I do, I would like to tell you that everything which I'm taking, I have used in this book. You can see that this is volume 1. This is one book, very heavy book. And eventually I would be using the volume 2, and I have ordered many more books from Amazon because law is all about interpretation. So whenever I am going to be interpret anything, I would be giving you the source also, that this source I am taking into consideration. So I repeat, this is a book by Justice R.N. Bhagwatji, Law of Arbitration and Conciliation, 6th edition by Anirudh Krishnan, Volume 1, LexisNexis. So guys, when you signed an agreement, any agreement, whether it's a building of home, buying a huge product, signing a financial documentation, any other thing, you need to have an arbitration agreement in that agreement. But today, I'm not talking about signing of homes, making of homes, ordering of huge amount of cars, and like that. I'm talking about very important, which is financial agreements. Now, I would like to bring one important thing before Honorable Supreme Court. Sir, when we sign any financial contract matters from party to party. So, sir, there are two type of contracts we have in finance. Number one, which is known as master service agreement, which we cannot change. It means that, example, ISDA master service agreement. ISDA stands for International Swaps and Derivative Association. Basically, it's a regulatory body much efficient than Indian regulators who controls the global derivative market. Of course, there are interpretation issues between me and ISTA as far as fallback language is concerned, which is nothing but the LIBOR transition. But the effort by ISTA in the LIBOR transition deserve an exemplary recognition. They did a wonderful job. If we compare this with RBI, then it is comparing Switzerland with Shimla. That's a difference, sir. So, sir, let's take an example. There are two customers. One is Apple, one is Amazon. Both are big companies. I don't think, sir, there is an introduction required. Now, in both companies, the situation differs. Example, Apple is little conservative, not very active. Not very active doesn't mean not from the product angle. So in product angle, they are very active, super active, launching a lot of products, X, Y, Z. Even last week they launched many products. But when it comes to treasury, little conservative company. The way they're signing the financial contracts is in a little different way. I'm not saying Apple is wrong. Apple has its own thinking. Amazon, in product launches, as active as Amazon, hardly any doubt. As active as Apple, hardly any doubt. In terms of treasury, they have to be super active. Because Apple is a majority importer followed by huge exporter. But Amazon in one country is importer, another country exporter, third country both, fourth country only importer, fifth country only exporter. Amazon's situation is completely different of what it is if we compare with Apple, maybe Google, maybe Microsoft, maybe Facebook. No offense to other companies, every company having a different business model. And as per the business model, the treasury function of this company is maintained and created. And one important thing which India always missed is the treasury function, respect to the treasury function. While American companies give appropriate remuneration, compensation, bonus, and talent appraisal to the treasury function. End results are, you see, operationally, they are not only more efficient, than Indian companies, but treasury wise, they are far ahead than Indian companies. Now, 1 year revenue of American banks is equals to many years revenue of Indian banks. This is the hard reality. Henceforth, the financial contracting of American system is not same we have in India. And sir, we also need to agree that India financial contracting is copied from America. Because example, sir, today if we take Amazon India, Google India, Infi India, TCS India, Wipro India, any company, they are all multinational companies, but when they sign an agreement, they follow the global standards. ISDA, Bank for International Settlement, all global standards. But these global standards are not fixed, they are flexible also. But I would like to stop here and I would like to bring something which I got in the book, sir, and I would like to request Honorable Supreme Court to please consider this. So I request the Supreme Court, I am reading this from the book, sir. Give me 1 minute, please. Okay. This is page number 15, very beginning, page number 15 of the book. So rather okay. Taking a correct view of the matter. So first it's a little dispute between Great Offshore Limited versus Iranian Offshore Energy and Construction Corporation. And this matter was sub judice before Honorable Supreme Court of India. Now, what Supreme Court did, they said that taking a correct view of the matter, Supreme Court rejected these contentions and held that Section 7 imposed no requirement that document must be an original and not a copy, and didn't require that the parties either stamp the document or sign every page. More importantly, the court construed the expression other means of telecommunication which provide a record of agreement correctly and held that it included a fax. So it means that Supreme Court is saying that the documents should not be an original, must not be an original, it can be a copy also. And there are other modes of expressions also. Okay, expression means communication. Okay, example, fax, probably, and all. Although, when the judgment was delivered, we were not having a great scale of WhatsApp and many other telecommunication platforms. So I'm not sure whether WhatsApp and all these things are considered here in this judgment or not. But one important point which I would like to bring up. In banking and the financial world, I repeat, sir, in banking and the financial world, the original document is required because of following reasons. Number one, document vary from company to company. The way Amazon India is signing a contract, Apple India might not be signing the contract. Alternatively, sir, after 2008, many additional documents being imposed by global regulators, not Indian regulator, global regulators like RDS, Risk Disclosure Statement, like Schedule to Annexure, STA, like Credit Support Annex, CSA, and many such documents. But sir, these all documents, whether Risk Disclosure Statement, Schedule to Annexure, Credit Support Annex, is just like a tea. Now what is tea? Tea means the drink we take. In tea, somebody takes no sugar, somebody takes one spoon, somebody take 2 spoon, somebody take 3 spoon. Now sir, can we generalize that? No, tea means 1 spoon. That is completely incorrect, because people take, even the respectable judges of Supreme Court, when they have their breaks, they definitely had tea. Everyone having their own sugar. Maybe somebody taking no sugar, somebody taking 3 spoons, somebody taking 2 spoons. But can we generalize that? No, we cannot generalize that. Similarly, these documents cannot be generalized and cannot be generalized. Since they cannot be generalized, in that sense, we need to make sure that the sender, suppose bank, JP Morgan Chase, example, and the receiver, suppose Apple India or Amazon India, simplistically, I'm just creating a hypothetical example. They need to sign this page on page basis. Even if we assume JP Morgan Chase, Goldman Sachs, Citi, and all these big guys, they are common to most of the companies. Common to most of the companies. But the way JP Morgan drafted this for Apple India, JP Morgan hasn't drafted, will not going to draft this for Amazon India. So how can JP Morgan say, how can we say that there is no need to sign on each page? I would like to repeat, sir. Please take a note. Taking a correct view of the matter, Supreme Court rejected these contentions and held that Section 7 imposed no requirement that the document must be an original and not a copy, and that it didn't require that the parties either stamp the document or sign every page. Most importantly, the court construed the expression other means of telecommunication which provide a record of the agreement correctly and held that it includes a fax. But there is a big thing, sir, in finance and especially in lending agreements. I'm sorry, but we cannot just take it the last page because each page is mandatory. So let's take an example. In derivatives, we have a contract called Master Service Agreement, which is known as MSA. No one in this world, whether you are Amazon, maybe Google, maybe any big company, you can have even a single change in the Master Service Agreement. Then you must be thinking that if you cannot change Master Service Agreement, then where my point is coming? My point is coming in the STA, Schedule to Annexure. It is just like Akbar and Birbal, sir. Like Akbar said to Birbal, there is a line on the board, and you cannot touch this line. Neither you can cut it, neither you can expand it. But you need to make a bigger line just parallel to that. What Birbal did, Birbal said, okay, he just draw a parallel line, job done. Similarly, sir, you cannot change MSA, but you can change STA, Schedule to Annexure. And sir, Schedule to Annexure is made corporate to corporate basis. And sir, it keeps changing. Example, as we speak in October 2021, rather October is about to close. Around 2 months from now, which is 31st December 2021, LIBOR transition is coming. Now, when LIBOR transition is coming, the first thing international banks will do, the ISDA agreements, International Swap and Derivative Association. It's a set of 4 documents, which is MSA, CSA, STA, and RDS. I repeat, sir, MSA, CSA, STA, and RDS. These 4 documents needs to be amended again. And I agree, it's a very big job. But can we have a common agreement for all companies, sir, when it comes to LIBOR transition? Maybe the amount of contracts in the book of Apple, maybe I just take a simplistic hypothetical example, it is 1 million. Maybe in the books of Amazon, it is 1 billion. So can we have a common agreement? Can we even think that there is no need to sign the each page? Alternatively, sir, that's very important, that in case of financial contracting, I repeat, sir, in case of financial contracting, there is a need of notary. So it is not like that you just, so you just send it without the notary, because the legal stamping is required. It means that You are signing this contract under this country law. Now, I will come later on seat of arbitration. That's a separate thing. I have my own interpretation issues on seat of arbitration, sir. But I would like to request the Honorable Supreme Court of India to please consider financial contracting, because Section 7 of Indian Arbitration Act is not a competent section, sir. Because financial contracting is a complete different ball game. It is like we are comparing the Apple iPhone, without quoting any other name, with some other company whose phone is nowhere equivalent to iPhone. And what are we talking is that this company phone should be compared with the iPhone. This is my interpretation, sir. And I am open to give my interpretation again to anyone in the world. But I feel that Section 7 of Indian Arbitration Act needs to be amended. And more important thing, sir, the very important thing which I would like to request is that can we have an arbitration clause in all contracts? Just think about that, sir. I'm just giving you a simplistic hint. There are four kind of liabilities we have in the world, whether it is India, US, Singapore, Malaysia, Australia, Germany, France, Russia, any country. You choose any country. Number one, when the amount is known, you can say payout. When the payout is known, but the time is not known. When the payout is known and the time is known. When the payout is not known, time is not known. When both are not known. Sir, in Section 7 of Indian Arbitration Act, you will see that the four which I talked it about completely missed. Because what is arbitration? Arbitration means a dispute. Now the resolution of the dispute in a conciliation way. Rather than wasting the time of the judiciary, it should be settled outside the judiciary and let judiciary interfere at the end, provided. But did in the arbitration clauses worldwide, except few where the IQ level is greater than 8, did judiciary ever thought that the 4 points which I told about the four kind of liabilities, did they are added in that arbitration agreements? Even I'm not talking about the author of this book. Author is separate. I'm talking about the law, the Bear Act. Did even the Bear Act talking about these four things in the arbitration acts? And when we speak about the financial contracts, and I talk very simplistically, sir, very simplistically, the arbitration contracts. What would if I take a swaptions, structured financial derivatives, LIBOR agreements? The thing would be completely different world. We don't have this in India. Hence, India tend to have opinion that these things don't exist. But they do. They do. So in this case, how can we say that each page is not required? So a structured derivative instrument signed between Amazon India and JP Morgan Chase India, both are the local subsidiary of a biggest bank, JP Morgan, and biggest company, Amazon India. And they created a clientele product. Clientele product means suitable for Amazon India. How can we say that no original copy is required? Because arbitration contract needs to touch each and every part of that contract. Each and every part of that contract. That's very important. And each and every page of that contract needs to be signed, which is a significance of the fact that the person read it And I would like to request, please consider this, sir, that not only sign, rather in case of financial contracting and space and simplistically speaking, complex financial contracting, rather I would say, not only sign, you need a stamping also. And not by the authorized signatory, sir, stamping by the company secretary, which means that the company secretary, as a law person in that organization, is aware about the consequences if they're not going to be following it. With this, I would like to request Honorable Supreme Court of India to please consider this, which is Section 7 of Indian Arbitration Act. At the end, I completely agree with one thought that contracting needs a holistic makeover worldwide, not only in India, worldwide. But unfortunately, very little emphasis is being paid on the contracting. And henceforth, in most of the cases, the judiciary time is waste. Judiciary is unnecessarily being involved in these situations, a lot of time being consumed. Had contracting is resolved or done at an appropriate way at the beginning, much of the issues could have resolved. But this is how the world works, the ground reality versus the practical reality. Thank you to Supreme Court of India for always assisting India, always giving the beautiful judgments. And thank you to the authors of this book for bringing this perspective. This video was not about to, degrade anybody's knowledge. Like I said, law means interpretation. So the way this book interpreted it, I interpret it in a little different way. But Treasury Consulting Group gives complete respect to this book, the authors of this book, the personalities of this book, and at the same point of time, it is our interpretation. This is how it should be interpreted. We are not going to disrespect anyone because interpretations differ. Example, 1 plus 1 equals to 2. But somebody come and say 2 plus 0 is also equals to 2. Now tell who is right, who is incorrect. You get to know. Thank you very much. This is Rahul from Treasury Consulting Group. You know my personal number, +91 9899 242 978. More interesting videos on arbitration decks on the cards. I would like to let the legal community of India, especially few law firms, very carefully. We are in the game. And our financial knowledge is beyond imagination. Have a great time ahead.